Hi, I'm Elizabeth Gearhart from Gearhart Law. I am here with James Klobucar, Senior Associate Patent Attorney, Intellectual Property Attorney at Gearhart Law. Hi, James.
Hi, Elizabeth. Thank you very much.
So we want to talk about different kinds of patents because there is some confusion and you really don't know what they are unless you're a patent professional. So what's the difference between a provisional patent and a non-provisional patent?
That's a good question. And, honestly, that's probably one of, if not the most asked question that I get from clients. And, the biggest difference is that there are less stringent filing requirements on a provisional. It's much easier to take an invention disclosure, a couple pictures, drawings, and to just file it with the patent office and get your filing date, if that's going to be important. A non-provisional is going to have a number of formal requirements that you have to meet, or you risk getting, a missing parts or, other issues that could even potentially result in not getting a filing date, even if you filed, the application. So those are the two largest, differences.
And that filing date's important because you use it to block other people who.
Right. Yeah. It's a first to file patent system, which, it's been that way since 2013. So most everyone has become accustomed to that. But yeah, the date that you file is it's important. It used to be if you could show that you invented the item previous, that you could kind of claw back to that date. But yeah, nowadays you just have to rely on the date that you file. And if you filed today and your competitor filed yesterday, your competitor beat you to the punch. So the date that you file is paramount.
And you don't know that your competitor filed yesterday because the patents are held in secret for like a year and a half, right?
Right.
I mean, the patent
right.
applications, not the patents.
Yep.
The patent applications are held in secret. So, but the provisional also gives you a year to make changes before you file the non-provisional, right?
It does, yeah. You have a year from the point that you file the provisional until you have to file the non-provisional. And during that year, let's say you have a prototype made, and that prototype doesn't work exactly how you describe the invention in the provisional. It happens all the time. In theory, what you put in the provisional sounds great. In practice, maybe not so much, right? So once that happens, all we need to do is go back, re-update, the material in the provisional, and then file it as a new provisional. When the time comes then to file the non-provisional application, you then have two provisionals or three or four, so forth, and you would claim priority to each of those at the time of the non-provisional filing.
I see. So then would you make the claims like broad enough in the first provisional so they covered pretty much anything you wanted to do in the non-provisional? If you
Yeah, I
could.
mean that's a good point, and that is something that is debated, between practitioners in terms of how best to include claims in a provisional. There's some practitioners who won't include claims in a provisional, but again, falling back to the first to file patent system. The date that you file the application is important. The information contained in the application is important well to establish, filing dates and priority dates. So the more complete of a job you can do up front, I'm of the opinion the better suited you're going to be down the line in the event that the patent is challenged or litigated or so on.
So are you of the opinion then that if somebody has a brand new idea, but they haven't really fleshed it out, they haven't checked out the manufacturing, they don't really know if it can be made the way they want, they should file the provisional anyway to get the date?
Yeah, absolutely. And oftentimes, if clients can sit there and say, "Here's my working prototype. It's not going to change, or I've market tested this. It's going into production," then yeah, definitely file the non-provisional. You really aren't going to need to take advantage necessarily of that 1 year benefit. But yeah, if you have an idea or a loose prototype, or maybe no prototype. Certainly a provisional is a good way to go. You don't have to wait the entire year. I mean, if 4 months down the line you're ready to go, then we can file the non-provisional. But I do think in all other instances, filing the provisional, isn't a detriment. Like I say, if you ever change your mind in the year time frame, you just file the non-provisional. And the 1 year period, you can label the product as patent pending. You are patent pending, and that 1 year that you're patent pending doesn't count against the patent term, because the patent term, the 20-year patent term, is calculated from the date of filing of the non-provisional. So that's an added bonus as well. So when you can take advantage of it, I think it makes sense to do so.
So the term's provisional kind of means it's not really the real thing, right?
Right.
And then non-provisional is what the patent office says, okay, this is the real patent now. So we're going to, or patent application, excuse me. I keep saying patent. I mean application. This is what we're actually going to look at and decide whether or not you can have a patent as a result of this application. So I guess you file the provisional if you feel like you need to do more work on the idea and you want to get the filing date.
Right.
And you don't have enough information, really. So,
yeah.
But if you have everything completely, this is what you're going to sell, then you could just go straight to the non-provisional.
Yeah, absolutely. And, we do have clients that do that with, great frequency. But we have clients that also file the provisional first.
So what do you think most of your clients do?
It's a good question. I would say a fair number do the provisional, first, being that we cater to startups and entrepreneurs. We do deal with a lot of people in the early stages of development, and the provisional gives them the patent pending status and protections that they need, while still giving them the flexibility to get everything else up and going, to get prototypes made, to shore up manufacturing, engineering design choices. So the provisional, I would say, is usually the way to go for most of the clients and with what I do. But there's a number that are set to go for the non-provisional.
Okay, and then there's other types of patents too, which
there are.
We're going to do another blog post on design patents. Okay. But there's also plant patents, which
correct
are a whole different category. We do those too.
Yep.
And is there anything else?
There's just the utility, the design, and the plants, and those are the kind of the three flavors, if you will, of patents.
So a lot of times people interchange utility and non-provisional, but they're not exactly the same, right?
Right. Yeah, I mean, I think that's a good point, to bring up, is that there's three types of patents: utility, plant, and design. And for a utility, you can file a provisional or a non-provisional. As far as plants and designs are concerned, you're really supposed to you file just a design patent, you file a plant patent. They don't have the same provisional considerations in those instances.
So which one gives you the most protection?
It really depends on what the invention is at the end of the day. Utilities protect methods, processes, function, the interrelationship of parts. Design applications protect the outward ornamental appearance, and plants, is for a new species of asexually propagated plant. So each one protects something a little different. So it just depends in terms of what your invention is.
So are the plant ones mostly GMOs then?
No, not necessarily. I mean, some are just, naturally, in some instances will be a naturally occurring mutation. Others are, are intentional, crossbreeding, and things of that nature. I think we were talking, before, apples are a big business in terms of people, protecting their apple cultivars and trademarking the names. And you go to the store and you see, it used to be, the typical, the Washington, the Macintosh, the Granny Smith, and now everywhere you see, Honey Crisp and all these different things that have, become a really big business for a lot of people. So, that's where, something like that would come into play.
Okay, great. Do you have anything else? Any final comments?
If you're unsure of what to do, certainly, seek out an attorney. That's the best way, because many times, right from the first get-go, it's, well, I don't really know what I need, but here's what I have. And, that's what we're here for. That's what we can help you out with, and we'd be more than happy to do so.
Yeah, so if you have any questions, give us a call.